Today, a collection of court documents quietly released into the public record has begun raising questions that were never meant to be asked. These are not tabloid leaks or anonymous tips. They are sworn statements, authenticated records, and materials produced during unrelated legal proceedings. None of them were initially connected to the royal family, celebrity relationships, or public scandal, and yet, when placed side by side, they begin to form a picture that is difficult to ignore. At the center of these materials are two high-profile figures whose lives until now have been understood through carefully managed public narratives: Meghan Markle and Rory McIlroy. What the documents suggest is not based on rumor or retrospective speculation, but on contemporaneous evidence created in real time, long before either individual had reason to imagine these records would ever be scrutinized. The first set of materials emerged from a civil lawsuit filed in New York involving a dispute between entertainment executives. The case itself had no connection to royalty, sports, or public figures. However, during the discovery phase, attorneys were required to turn over extensive digital communications. Buried among thousands of unrelated messages were repeated exchanges between a phone number associated with Meghan Markle and another associated with Rory McIlroy. The messages date back to mid-2017, a period that predates the public confirmation of Markle's relationship with Prince Harry. Several of these messages were highlighted in court filings because they were unusually personal in tone and irrelevant to the business dispute at hand. They were not logistical, professional, or casual. They were intimate, language describing emotional connection, anticipation of future meetings, and references to recent time spent together appeared repeatedly. These messages were time-stamped, preserved in their original digital format, and submitted under oath as part of evidentiary exhibits. No party involved has disputed their authenticity. What makes these messages significant is not just their content, but their timing. They were sent during a period when Markle's public narrative would later emphasize privacy, discretion, and exclusivity regarding her personal life. Yet these communications indicate an ongoing, emotionally charged relationship with someone other than the individual she would soon be linked to publicly. A second document adds further context. In a separate employment-related lawsuit filed in California, a hotel employee submitted a sworn affidavit describing an encounter that, at the time, seemed unremarkable but later gained significance. The employee worked overnight shifts at a luxury hotel in Beverly Hills during August of 2017. In the affidavit, the employee states that a woman and a man checked into a private suite under corporate aliases and made specific requests for privacy, including no housekeeping services and limited staff access. The affidavit identifies the woman as Meghan Markle and the man as Rory McIlroy. The employee explained that both were immediately recognizable due to their media presence. The statement was given under penalty of perjury and includes detailed descriptions of their behavior, their requests, and the duration of their stay. According to the affidavit, the pair remained in the suite for 3 consecutive days and did not leave together during that time. This testimony was not solicited as part of any investigation into either individual. It was included because the employee was recounting all notable encounters during their employment as part of a broader pattern of treatment claim against the hotel. Attorneys reviewing the affidavit later flagged it due to the specificity of the identification and the unusual privacy measures described. Independent records appear to corroborate the timing. Commercial and private aviation logs show that Rory McIlroy traveled from Dublin to Los Angeles during the exact window referenced in the affidavit. Separately, a calendar maintained by Meghan Markle's assistant, which was submitted as evidence in a workplace dispute involving a former staff member, lists her as unavailable during that same period. The calendar entry is brief but notable: 3 consecutive days marked as personal time, with instructions not to schedule meetings or communications. These records were never intended to be cross-referenced. They originated in different jurisdictions, involved different legal teams, and were produced for unrelated purposes. Yet together they place both individuals in the same city, at the same hotel, during the same dates. The pattern does not stop there. In 2018, a London-based photography agency became involved in a copyright lawsuit that required it to surrender its entire archive of unpublished images. Among tens of thousands of photographs were a small set taken at a private golf resort in Scotland during June of 2017. The images show Meghan Markle and Rory McIlroy together in informal settings. They are not photographed at a public event or charity function. They appear relaxed, familiar, and physically close. In one image, McIlroy's arm is positioned around Markle's waist. In another, they are seated closely on a bench overlooking the course, with Markle leaning into him. These images were never released to the press, despite the agency's routine practice of monetizing celebrity photographs. Internal correspondence also produced during discovery indicates that a decision was made not to distribute the images and that a payment was received in exchange for keeping them private. The identity of the pair is redacted in the court filing. What raises further questions is that the photographs remained unpublished even after Markle's global profile changed dramatically. At that point, their news value would have been undeniable. Yet the suppression held. Additional documentation points to sustained coordination behind the scenes. Phone records obtained through legal discovery in a telecommunications case show frequent communication between an assistant linked to Markle and a business manager associated with McIlroy. Over a 7-month period in 2017, the two numbers exchanged hundreds of calls and messages. These were not one-off interactions. They were consistent, ongoing, and occurred during periods when both principals were traveling internationally. In professional contexts, assistants communicate frequently, but the volume and timing of these exchanges stood out to attorneys reviewing the records. The communications spiked around known travel windows and dropped off during periods when both individuals were publicly documented as being in the same location. Internal emails from McIlroy's management team, later introduced in a contractual dispute with a former agent, add another layer. In one message dated October 2017, a staff member refers to the need for short-notice travel arrangements, emphasizing discretion and adherence to previously established protocols. The language is vague but deliberate, suggesting a routine that required confidentiality rather than standard scheduling. Perhaps the most direct testimony comes from a security consultant who worked for McIlroy during that period. In a sworn deposition, the consultant describes being tasked with arranging secure transportation and private access for meetings involving a woman he later identified as Meghan Markle. He stated that his instructions were explicit: ensure privacy, avoid public exposure, and facilitate discreet entry and exit from properties. The consultant emphasized that this was not a one-time request but part of a recurring assignment during the summer and fall of 2017. This testimony was given under oath and was not challenged by opposing counsel. It was included as background information in a case unrelated to personal relationships, yet it provides a rare, inside view of how much effort was devoted to maintaining secrecy. None of these documents, on their own, would necessarily command public attention. Text messages can be misinterpreted. Hotel stays can be coincidental. Photographs can lack context. But taken together, across multiple jurisdictions, legal proceedings, and independent sources, they form a consistent narrative. What emerges next is not simply an extension of the paper trail, but the broader meaning of what that trail suggests. When legal documents surface independently, across different cases, jurisdictions, and years, they often reveal more through their overlap than through any single statement. At this stage, the question is no longer whether contact occurred, but what that contact meant, who knew about it, and who did not. One of the most consequential aspects of this timeline concerns awareness, specifically what Prince Harry understood about Meghan Markle's personal life during the early stages of their relationship. Several pieces of testimony indirectly address this issue, not through direct statements from Harry himself, but through the accounts of people in his social and professional orbit. In a defamation case involving a British tabloid, a recorded interview was entered into evidence by a private investigator hired to assess credibility of sources. In that interview, a longtime acquaintance of Harry described the period during which he began dating Markle. The account portrays Harry as deeply invested and emotionally committed, frequently discussing his relationship and expressing certainty about its future. The same individual acknowledged that there were rumors circulating privately at the time involving Markle and another high-profile figure, but emphasized that these rumors were never substantiated with proof and were therefore dismissed or intentionally ignored. What is notable is not the existence of rumors, which are common in elite social circles, but the reluctance described by the interviewee to confront Harry with them. According to the recording, friends feared causing harm based on unverified information and believed that if anything serious existed, it would be disclosed voluntarily. With the benefit of documented evidence now available, that assumption becomes questionable. Further insight comes from depositions given by individuals who worked directly for Markle during her acting career in North America. One former staff member, testifying in an unrelated employment dispute, described a pattern of frequent, unexplained travel during weekends throughout 2017. According to the deposition, Markle would often leave on Fridays and return late on Sundays or Mondays, providing vague explanations about visiting friends, but declining to specify locations. The same staff member recounted an instance in which a message appeared on Markle's phone while she was sharing unrelated information. The message referenced an imminent arrival in Dublin at The time, the staff member recalled being surprised, as Markle had previously indicated she would be in New York that weekend. No clarification was offered. Only later, when reviewing timelines involving Rory McIlroy, did the discrepancy stand out. These details matter because they speak to intentional concealment rather than coincidence. Concealment requires effort. It requires consistent narratives, selective disclosure, and coordination with others who manage logistics. That coordination is documented elsewhere. Phone records introduced during a telecommunications lawsuit show sustained communication between representatives acting on behalf of Markle and McIlroy. The frequency of these exchanges suggests planning rather than incidental contact. Assistants do not typically communicate hundreds of times without a recurring operational need. The records show that these communications often aligned with travel periods, hotel stays, and known gaps in public schedules. There is also evidence that secrecy was not limited to personal discretion, but extended into professional risk management. Internal correspondence from a public relations firm representing McIlroy, later disclosed in a fee dispute, references the need for crisis management strategies in anticipation of possible exposure related to personal matters from mid to late 2017. The memo advises preparation of statements and a media blackout plan, and explicitly notes that the situation involves a high-profile individual outside the sports world. That phrasing is revealing. It narrows the scope significantly. It implies involvement with someone whose public profile would attract attention beyond sports journalism. At that time, Markle was transitioning from a successful but relatively contained acting career into a far more visible role. The need for crisis planning suggests that those involved understood the potential consequences if details became public. The timeline also intersects with McIlroy's own marital history. He married Erica Stahl in April 2017. Court records show that the marriage ended years later, with divorce proceedings initiated in Florida. While the filing itself uses standard language, subsequent motions submitted by Stahl's legal team requested sealed testimony regarding extramarital associations occurring before and during the marriage. The court granted that request. Sealed testimony is not unusual in high-net-worth divorces, but it is not automatic. Courts typically approve such requests only when sensitive information is deemed both relevant and potentially damaging. The timing referenced in the motion aligns precisely with the period documented elsewhere through messages, travel records, and third-party testimony involving Markle. None of the sealed testimony has been made public, and no direct reference to Markle appears in the accessible filings. However, the overlap in dates raises legitimate questions about whether these matters were among those the court agreed to shield from disclosure. What complicates this further is that none of these revelations were the result of a targeted investigation into either individual. They surfaced incidentally through routine legal processes where disclosure obligations required full transparency, unrelated to celebrity or public interest. In effect, these records exist because the law demanded completeness, not because anyone sought to expose a relationship. This distinction is critical. It means the evidence was not curated or selectively leaked. It was preserved as part of formal proceedings, often long before any reason existed to connect the individuals involved. That lends weight to the consistency observed across documents. The broader implication concerns narrative integrity. Public understanding of relationships involving public figures is often shaped by carefully managed disclosures, selective interviews, and strategic silence. That does not inherently imply dishonesty. Privacy is a legitimate concern. However, when multiple independent records indicate deliberate misrepresentation to different audiences at different times, the issue shifts from privacy to trust. If Markle maintained a concealed relationship during the period in which her public relationship with Harry was forming, it raises questions about informed consent. Did Harry have a complete understanding of the situation he was entering? Did those around him possess information they chose not to share? Or was the truth compartmentalized in such a way that plausible deniability could be maintained by all parties involved? These are not questions that can be answered definitively through documents alone. They require acknowledgement from those involved. To date, no such acknowledgement has been forthcoming. Representatives for Markle have declined to comment on the documents. McIlroy's team has issued general denials without addressing specific records. The palace has maintained silence. Silence, however, does not erase records, nor does it resolve inconsistencies. Instead, it allows speculation to fill the gap, often in ways that are less charitable than direct engagement would be. There is also the matter of scale. The evidence that has surfaced represents only what has become visible through accidental convergence. Tens of thousands of pages remain sealed in courts across multiple countries. Many involve business disputes, employment claims, and contractual disagreements that have nothing to do with personal relationships on their face. Yet embedded within them may be additional references, communications, or corroborating details that have not yet been examined in context. If this much alignment can be identified without a centralized investigation, it suggests that the full picture, were it ever assembled deliberately, could be far more detailed. Ultimately, this is not a story about scandal for its own sake. It is about accountability and narrative control. Public figures benefit from trust. The trust is built on the assumption that while not every detail is shared, the core representation of events is fundamentally honest. When evidence emerges that challenges that assumption, it invites reassessment, not just of individual actions, but of the broader narratives constructed around them. In this case, the question is whether the foundation of a globally significant relationship was as transparent as it was presented to be. For Prince Harry, the implications are deeply personal. If he was unaware of the full scope of events during the formative period of his relationship, then decisions affecting his life, his family, and his role were made without complete information. If he was aware and chose silence, then the public narrative surrounding subsequent events takes on a different meaning. For the public, the relevance lies in understanding how narratives are shaped and maintained. This case illustrates how truth can exist in fragments, scattered across legal filings and testimony, waiting for context to bring it into focus. What happens next depends on whether those involved choose to address the evidence directly or continue to rely on silence and general denials. History suggests that documents, once released, have a way of resurfacing, and when they do, they tend to raise more questions than they answer. What can no longer be disputed is that the records exist, the timelines intersect, and the concealment was real. Whether that concealment was justified, ethical, or damaging is a matter that remains unresolved. But the presence of so much corroborated material ensures that the conversation is no longer hypothetical. At some point, the question shifts from what can be hidden to what must be explained. And when that moment arrives, it will not be driven by rumor, but by the same mechanism that brought this information to light in the first place.